Get a grip, then get a chip. Won't even trip. Though my cup was running over, I took only a sip. Stay hippin', then I'm hopping, I'm dropping. It won't be flopping, no shock. That whatever I'm selling, you will be copping. He was the strongest, though he was the one that cried. And he chose to kill his brother because he was from that side. And why? He chose this son because this one had pride. And instead of the narrow road, he chose the one that's why. Sometimes the one that won was the one that tried. And the one who pulled the gun was the one that died. Looking good, a good look is the one that's fine. If I had to pick, fly would be the one that's mine. G-O-D, in the place to be. Attendee, Hard Knocks University. And since kindergarten, they've been hiding the knowledge. Homeboy is self-taught, never went to college. I'm brown skinned, I'm from Pelon. Rainy alarm, then I remain cool and calm. Reading Psalm, fire like napalm bomb. As we proceed to give you what you need, we're going over the Annotated Glossary from Cracking the Code, 3rd edition, starting where we left off. So without further ado, let us begin. Chattel, an article of personal property, any species of property not amounting to a freehold or fee in land. The terms chattels is a more comprehensive one than goods, as it includes animate as well as inanimate property. Blacks first. Chattel mortgage, an absolute pledge to become an absolute interest if not redeemed at a fixed time. Bouvier 8. Chattel paper means a record or records that evidence both a monetary obligation and a security interest in specific goods. A security interest in specific goods and software used in the goods. A security interest in specific goods and license of software used in the goods. A lease of specific goods, or a lease of specific goods and license of software used in the goods. In this paragraph, monetary obligation means monetary obligation secured by the goods or owed under a lease of the goods and includes a monetary obligation with respect to software used in the goods. The term does not include 1, charters or other contracts involving the use or hire of a vessel, or 2, records that evidence a right to payment arising out of the use of a credit or charge card or information contained on for use with the card. If a transaction is evidenced by records that include an instrument or series of instruments, the group of records taken together constitutes chattel paper. UCC 9102A11. Citizen, in American law, one of the sovereign people, a constituent, member of the sovereignty, synonymous with the people. Scott versus Sanford. Bouvier's 8th. Citizens are members of a political community who, in their associated capacity, have established or submitted themselves to the dominion of a government for the promotion of their general welfare and the protection of their individual as well as collective rights. Blacks 6. Civil law, that body of law which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and from international law. The system of jurisprudence held and administered in the Roman Empire, particularly as set forth in the compilation of Justinian and his successors, comprising the institutes, code, digests, and novels, and collectively denominated the Corpus Juris Civilis, as distinguished from the common law of England and canon law. Blacks 6. See municipal. Citizen. Compare common law. Claim, a challenge of property or ownership of a thing which is rightfully withheld, to demand as one's own, to assert a right or title. Blacks 4. See note. Note, a claim is a dispute over title, most fundamentally concerning who holds the legal title to your name, who holds the legal title to your trade name. The holder of legal title to your trade name is the master and creditor. Your straw man is the slave and debtor. We must reclaim and reunite right and title to our straw man in order to dissolve the bonds of indentured servitude. The subject citizen is the straw man. You are the sovereign. Per the UFC, acquiring rights evidences value. You acquired rights to title of your straw man at the moment of his birth. See value. Droit. Clearfield Trust Doctrine. Governments descend to the level of a mere private corporation and take on the characteristics of a mere private citizen, where private, corporate, commercial paper, Federal Reserve notes, and securities checks is concerned. For purposes of suit, such corporations and individuals are regarded as entities entirely separate from government. Clearfield Trust versus United States, 318 U.S. 363 to 371. That's in 1942. Stare decisis, Latin to stand by things decided. The doctrine of precedent, under which it is necessary for a court to follow earlier judicial decisions when the same points arise again in litigation. Black seventh. Client. A client is one who applies to a lawyer or counselor for advice and direction in a question of law, or commits his cause to his management in presenting a claim or defending against a suit in a court of justice. One who retains the attorney is responsible to him for his fees, and to whom the attorney is responsible for the management of the suit. One who communicates facts to an attorney, expecting professional advice. Clients are also called wards of the court in regard to their relationship with their attorneys. Corpus Juris Secundum, 1980, Section 4. See note, attorney and client. Note, clients are wards of the court. In other words, infants and persons of unsound mind. The scarecrow straw man in The Wizard of Oz was a person of unsound mind. See wards of court, attorney and client, Wizard of Oz. Code, a system used for brevity or secrecy of communication in which arbitrarily chosen words, letters, or symbols are assigned definite meanings. Webster's, a collection, compendium, or revision of laws, a complete system of positive law, scientifically arranged and promulgated by legislative authority. Black's fourth, see note. Note, all law today is code, and as such must be deciphered, decoded. Code of Federal Regulations, the annual of executive agency regulations published in the Daily Federal Register, combined with previously issued regulations that are still in effect. Black seventh. Code of Hammurabi, the oldest known written legal code produced in Mesopotamia during the rule of Hammurabi, who reigned from 1792 to 1750 BC. Black seventh. A king of Babylonia who expanded his kingdom into the first great Babylonian empire. He also established one of the earliest written collections of laws. Hammurabi based his code of laws on older collections of Sumerian and Akkadian laws, which he revised and expanded. One principle of the Code of Hammurabi is that the strong shall not oppress the weak. The code begins with a prologue introduction celebrating Hammurabi's military victories. He promises to treat conquered peoples justly and says he honors their gods. The provisions of the code cover many legal matters, including false accusation, witchcraft, military service, land and business regulations, family laws, tariffs, wages, trades, loans, and debts. The World Book Encyclopedia 2000. Collateral. Collateral means the property subject to a security interest or agricultural lien. The term includes all of the following. A. Proceeds to which a security interest attaches. B. Accounts, shadow paper, payment intangibles, and promissory notes that have been sold. C. Goods that are subject of a consignment. UCC 9102A12. Anything that is used to guarantee the payment of a loan or the fulfillment of some other obligation. C. Note. Note, the property subject to a security interest, the collateral, is your trade name, and by implication, your body, labor, and property. Your birth certificate is shadow paper, a security. Accounts does not exclude Social Security account numbers, SSANs. The U.S. government has a legal security interest in both your trade name and its SSAN. Color, semblance, disguise. Color is often used to designate the hiding of a set of facts behind a sham, taking advantage of the confidence, but technically proper legal theory or legal right. Barron's third, see color of law. Color of law, the appearance or semblance without the substance of legal right. Misuse of power, possessed by virtue of state law and made possible only because wrongdoer is clothed with authority of state, is action taken under color of law. Black's fifth. Colorable, that which is in appearance only and not in reality what it purports to be, hence counterfeit. Feigned, having the appearance of truth. Black's fifth. In the law of trademarks, this phrase denotes such a close or ingenious imitation as to be calculated to deceive ordinary persons. Black's fifth. See note. Colorable equals phony. Commerce, equivalent to commerce, to trade together. The exchange of goods, productions, or property of any kind. The buying, selling, and exchanging of articles. The transportation of persons or property by land, water, and air. The various agreements which have for their object facilitating the exchange of the products of the earth or the industry of man with an intent to realize a profit. Black's first. An interchange of goods or commodities, especially on a large scale between different countries. Foreign commerce, or between different parts of the same country. Domestic commerce. Sexual intercourse. Webster's, commerce is a term of the largest import. It comprehends intercourse for the purpose of trade in any and all of its forms, including the transportation, purchase, sale, and exchange of commodities between the citizens of our country or the citizens or subject of other countries, and between the citizens of different states. The power to regulate it embraces all the instruments by which such commerce may be conducted. Blacks first, the exchange of goods, productions, or property of any kind, the buying, selling, and exchanging of articles, intercourse by way of trade and traffic between different peoples or states, including not only the purchase, sale, and exchange of commodities, but also the instrumentalities and agencies by which it is promoted and the means and appliances by which it is carried on, and transportation of persons as well as goods, both by land and sea, also interchange of ideas, sentiments, etc., as between man and man. Blacks fifth. See note, maxims of commerce. Note, commerce in everyday life is the vehicle or glue, bond tissue that holds or binds the corporate body politic, society as a whole together. Per Title 27, United States Code, or USC, subsection 7211, all crime is classified as commercial in nature. This is admiralty jurisdiction. See UCC definition of defendant in this glossary, and the item entitled Prisoners, Prisons, and Courts, as well as the above mentioned 27 United States Code 72.11 under crime is commerce, an appendix for examples of this. More specifically, commerce consists of a mode of interacting, doing business, resolving disputes, etc., whereby all matters are executed under oath, certified on each party's commercial liability by sworn affidavit or what is intended to possess the same effect as true, correct, and complete, not misleading, the truth, the whole truth, and nothing but the truth. This affidavit format is usually required in written matters such as an IRS Form 1040, an application form for a driver's license, voter's registration, a Treasury Direct account, a notary's copy certification by document custodian form, and on nearly every single document upon which those in the system desire others to be bound/obligated. Such means of signing is a sworn oath. In other words, affidavit executed under penalty of perjury, true, correct, and complete, whereas in a court setting, testimony, oral affidavit is stated in judicial terms by being sworn to be the truth, the whole truth, and nothing but the truth, so help me God. In addition to asserting all matters under solemn oath of personal, commercial, financial, and legal liability for the validity of each and every statement, the participant must provide material evidence. In other words, ledgering, bookkeeping, proving the true validity, relevance, and verifiability of each and every particular assertion to sustain credibility. In society, commerce comes before and is more essential than a legal system and can exist independently of and function without need of legal systems. Commercial law, the non-statutory variety as presented in maxims 1 through 10 under maxims of commercial law, is the economic extension of natural law order into man's social world and is universal in nature. See maxims of commercial law. Commercial law, a phrase used to designate the whole body of substantive jurisprudence. Example given, Uniform Commercial Code, Truth in Lending Act, applicable to the rights intercourse of persons engaged in commerce, trade, or mercantile pursuits. Black 6. See note, commerce, maxims of commercial law. Note, commercial law is the economic extension of natural law into man's social world and deals with the fundamental principles of human interaction concerning proof of claim, despite over title, and resolution of disputes. The fundamental purpose of commercial law is to maintain the commercial harmony, integrity, and continuity of society, sometimes also states as to maintain the peace and dignity of the state. Over the millennia, these principles have been discovered through experience and distilled and codified into 10 fundamental maxims. There is no legal issue or dispute possible which is not a function of one or more of these principles. The 10 maxims underlying commerce and all commercial law, including the UCC, are listed above under commerce. The UCC is a particular codification of commercial law oriented towards the contemporary legal, financial, monetary, and banking systems. The entirety of world commerce now functions in accordance with the UCC version of commercial law. Commercial tort claim. Commercial tort claim means a claim arising in tort with respect to which either the following conditions are satisfied. A, the claimant is an organization. B, the claimant is an individual, and both of the following conditions are satisfied regarding the claim. 1, it arose in the course of the claimant's business or profession. 2, it does not include damages arising out of personal injury to or the death of an individual. UCC 9102-813. Common law. The common law is that which derives its force and authority from the universal consent and immemorial practice of the people. It has never received the sanction of the legislature by an express act, which is the criterion by which it is distinguished from the statute law. It has never been reduced to writing. By this expression, however, it is not meant that all those laws are at present merely oral or communicated from former ages to the present solely by word of mouth, but that the evidence of our common law is contained in our books of reports and depends on the general practice and judicial adjudications of our courts. Two, the common law is derived from two sources, the common law of England and the practice and decision of our own courts. In some states, the English common law has been adopted by statute. There is no general rule to ascertain what part of the English common law is valid and binding. To run the line of distinction in a subject of embarrassment to courts and the want of it a great perplexity to the student, it may, however, be observed generally that it is binding where it has not been superseded by the Constitution of the United States or of the several states, or by their legislative enactments, or varied by custom, and where it is founded in reason and consonant to the genius and manners of the people. Three, the phrase common law occurs in the seventh article of the amendments of the Constitution of the United States. In suits at common law, where the value in controversy shall not exceed $20, says that article, the right of trial by jury shall be preserved. The common law here mentioned is the common law of England and not of any particular state. The term is used in contradistinction to equity, admiralty, and maritime law. Four, the common law of England is not in all respects to be taken as that of the United States or of the several states. Its general principles are adopted only so far as they are applicable to our situation. Bouvier 6, see note. Note, system of jurisprudence that originated in England and was later applied in the United States and the several states, originally based on the procedures developed by free sovereign allodial landowners to resolve disputes over land, such as borders and ownership. After the Norman conquest of 1066, common law came to be based on judicial precedent, court decisions that was increasingly absorbed into the crown. By such means, what is called common law in name became increasingly Roman civil law. True common law is completely independent of all governmental involvement. All governments are variants of Roman civil law, the law of kings, princes, and rulers. Nevertheless, common law remained based on transmitted established principles rather than legislative enactment, statutes, statutory law codes. Great care should be used concerning the precise manner in which the term common law is defined, understood, and used. One should ascertain the implication of the words, example given, what law is common, where, and to what. Traditionally, in the absence of statutory law regarding a particular subject, the judge-made rules of common law are the laws of that subject, are the laws on that subject. Thus, the traditional phrase at law refers to the state of the law in a particular field prior to the enactment of legislation in that field. Compare statute, Roman civil law. Communicate. Communicate means to do any of the following. A, to send a written or other tangible record. B, to transmit a record by any means agreed upon by the person sending and receiving the record. C, in the case of transmission of a record to or by a filing office, to transmit a record by any means prescribed by filing office rule UCC 9102A18. Complaint. In civil practice, this is in those states having a code of civil procedure. The complaint is the first or initiatory pleading of the part of the plaintiff in a civil action. It corresponds to the declaration in the common law practice. In criminal law, a charge preferred before a magistrate having jurisdiction that a person named or an unknown person has committed a specific offense with an offer to prove the fact to the end that a prosecution may be instituted. It is a technical term, descriptive of proceedings before a magistrate. The complaint is an allegation made before a proper magistrate that a person has been guilty or of a designated public offense. Blacks first. Note, a private man cannot commit a public offense. Only a public man, straw man, trade name can commit a public offense. Conference of Governors, March 6, 1933. See note. Note, accommodation of the federal bankruptcy whereby the governors of the 48 several states of the Union pledged their faith and credit to the aid of the national government and therefore formed numerous socialist programs such as the Council of State Government, Social Security Administration, etc., purportedly to deal with the economic emergency. They operated under the Declaration of Interdependence of January 27, 1937, and published some of their activities in the Book of the States, Volume 2, page 144. See in this state. Constitutor. In civil law, he who promises by a simple pact to pay the debt of another. And this is always a principal obligation. Bourvier's eighth. In the civil law, one who by a simple agreement becomes responsible for the payment of another's debts. Blacks first. A person who by agreement becomes responsible for the payment of another's death. Black 7. Note, when you sign a traffic ticket, you become the constitutor for the debt created by the policeman. See Senate Document 43, 73rd Congress, First Session, and House Joint Resolution 192 of June 5th, 1933, for clarification of why this is so. Money is brought into existence by borrowing. The cop creates the new money by issuing a charge in his name. He signs the ticket first. His intent is to transfer the debt to you as a constitutor. If you adopt the role of authorized representative or agent, you incur no liability for signing because you are not signing as a principal. Signing the ticket by order of name of cop, John Henry Doe, by John Henry Doe, authorized rep or agent, leave you without responsibility for payment or performance as you are not a constitutor. See how to sign your signature without liability on page 315 in section 10 for further explanation. Constructive, that which is established by the mind of the law in its act of construing facts, conduct, circumstances, or instruments, that which has not the character assigned to it in its own essential nature, but acquires such character in consequence of the way in which it is regarded by a rule or policy of law, hence inferred, implied, made out by legal interpretation, the word legal being used sometimes in lieu of constructive. Black's 4th, see note. Note, corpus juris secundum describes a government as a constructive trust. Black's 5th defines constructive trust as a mixture of law and fraud. Today, all courts are private commercial tribunals collecting from the assets. In other words, every citizen of the United States in the Chapter 11 reorganization and bankruptcy of the U.S. As such, every court today is a court of general equity wherein the judge can pick and choose from any body of law on earth in forming his decision, with the final basis of decision making being the conscience of the court, meaning whatever the judge feels. All such courts are corporate contract courts, dealing with fictitious entities and contracts between them. The straw man of each disputant or party to the controversy is within the bankruptcy and the corporate U.S., which is a public trust under the 14th Amendment. Such an arrangement has only two parties, co-trustee and co-beneficiary. A public trust has no creator, trustor, grantor, settlor, as with an express trust, which involves three parties, not two, as with the public trust. In sifting, sorting, and selecting from the law and facts of a case, a judge forms a constructive trust in which the judge constructs the terms of the particular trust contract emerging out of the dispute. A trustee of a public trust has duties and obligations. A beneficiary receives or derives benefits from the trust. Every straw man trade name today has duties as a co-trustee along with privileges as a co-beneficiary of the public trust. Consequently, in every court case today, the judge is constructing the terms of the constructive trust to decide which straw man owes the other straw man what recompense specific performance. Consumer goods. Consumer goods means goods that are used or bought for use primarily for personal, family, or household purposes. UCC 9102A23. See note. Note, per this definition, an automobile used primarily for personal, family, or household purposes qualifies as consumer goods. Consumer transaction. Consumer transaction means a transaction in which one, an individual incurs an obligation primarily for personal, family, or household purposes. Two, a security interest secures the obligation. And three, the collateral is held or acquired primarily for personal, family, or household purposes. The term includes consumer goods transactions. UCC 9102-826. Assignments of commercial deposits accounts are governed by revised Article 9. Although assignments of deposit accounts and consumer transactions remain excluded, notes Penelope Christoporou of Cleary, Gottlieb, Stein, and Hamilton in New York City, the definition of consumer transaction in revised Article 9 does not include a monetary component, she says, and as a result, certain pledges of deposit accounts by net worth individuals and transactions entered into for personal, family, or household purposes would be excluded from revised Article 9's coverage, notwithstanding the size of the financing. That's William C. Smith, ABA or American Bar Association Journal, August 2001, page 54. See note. Note, assignment of deposit, checking, saving, passbook, time, accounts, and transactions entered into primarily for personal, family, or household purposes are not addressed in revised Article 9. Contract, an agreement between two or more persons which creates an obligation to do or not to do a particular thing. Its essentials are competent parties, subject matter, a legal consideration, mutuality of agreement, and mutuality of obligations. Black's 5th. Note, all contract, whether express or implied, are subject to the universal essentials of contract law. pertaining to the fundamentals of the interactions between the parties. These fundamentals are well codified in many places. Example given: the California Civil Code, sections 1549 et sec. 1549, contract. What is a contract? What a contract? What a contract is an agreement to do or not to do a certain thing. In subsection 1550, essential elements of a contract. It is essential to the existence of a contract that there should be: 1, parties capable of contracting; 2, their consent; 3, lawful object; and 4, a sufficient cause or consideration. Subsection 1556, who may contract. All persons are capable of contracting except minors, persons of unsound mind, and persons deprived of civil rights. 1565, essentials of consent. The consent of the parties to a contract must be: 1, free; 2, mutual; and 3, communicated by each to the other. Subsection 1567, an apparent consent is not real or free when obtained through: 1, duress; 2, menace; 3, fraud; 4, undue influence; or 5, mistake. Subsection 1598, when contract wholly void. When a contract has but a single object and such object is unlawful, whether in whole or in part, or wholly impossible of performance, or so vaguely expressed as to be wholly unascertainable, the entire contract is void. Subsection 1608, effects of its illegality. If any part of single consideration for one or more objects, or of several considerations for a single object, is unlawful, the entire contract is void. Subsection 1620, express contract. What? An express contract is one, the terms of which are stated in words. Subsection 1621, implied contract. What? An implied contract is one, the existence and terms of which are manifested by conduct. Subsection 1441, impossible or unlawful conditions void. A condition in the contract, the fulfillment of which is impossible or unlawful within the meaning of the article of the object of contracts, or which is repugnant to the nature of the interest created by the contract, is void. Subsection 1636, contracts, how to be interpreted. A contract must be so interpreted as to give effect to the mutual intention of the parties as it existed at the time of contracting, so far as the same is ascertainable and lawful. Subsection 1668, certain contracts unlawful. All contractors have for their object, directly or indirectly, to exempt anyone from responsibility for his own fraud or willful injury to the person or property of another, or violation of law, whether willful or negligent, or against the policy of the law. Subsection 1709, fraudulent deceit. One who willfully deceives another with intent to induce him to alter his position to his injury or risk is liable for any damage which he thereby suffers. Contribution. Contracts. When 2 or more persons jointly owe a debt and one is compelled to pay the whole of it, the others are bound to indemnify him for the payment of their shares. This indemnity is called a contribution. Bouvier 6. When one of several debtors pays a debt, the creditor is bound in conscience, if not by contract, to give to the party paying the debt all his remedies against the other debtors. Bouvier 6. A right to contribution exists in the case of debtors who owe a debt jointly which has been collected from one of them. Bouvier's 8. The right that gives one of several persons who are liable on a common debt the ability to recover ratably from each of the others when that one person discharges the debt for the benefit of all. Black 7th, war contribution. Black 7th, see war contribution, Ponzi scheme, the curse of co-suretyship in part 1 of this manual. Convey, to transfer as property or title to property from one person to another. American Heritage Dictionary. Corporation, an artificial person or legal entity created by or under the authority or laws of a state. An association of persons created by statute as a legal entity. The law treats the corporation itself as a person that can sue and be sued. The corporation is distinct from the individuals who comprise it. Shareholders. The corporation survives the deaths of its investors, as the shares can usually be transferred. Black 6. See corporation. Aggregate corporation sole, public corporation. Corporation aggregate. A corporation aggregate is one composed of a number of individuals vested with corporate powers. And a corporation, as the word is used in general, popular, and legal speech, and as defined at the head of this title, means corporation aggregate. Blacks 6. Compare corporation sole. Corporation sole. A corporation consisting of one person only and his successors in some particular station, who is incorporated by law in order to give his successors in office some legal capacities and advantages, particularly that of perpetuity within their natural persons, they could not have had. In this sense, the sovereign in England is a sole corporation, so is a bishop, so are some deans, distinct from their several chaplains, and so is every parson and vicar. A corporation's soul consists of a single person who's made a body corporate and politic in order to give him some legal capacities and advantages, and especially that of perpetuity, as a bishop, dean, etc. Lacks first. Lacks first. Compare corporation aggregate. Corruption, an act done with an intent to give some advantage inconsistent with official duty and the right of others. The act of an official or fiduciary person who unlawfully and wrongfully uses his station or character to procure some benefit for himself or for another person, contrary to duty and the rights of others. Lacks fifth. Co-sureties, joint sureties, two or more sureties to the same obligations. Lacks fourth. See suretyship, see surety. Co-surety, a surety who shares the cost of performing suretyship obligations with another. Lacks seventh. See surety, suretyship. Co-suretyship, see suretyship. Coven, a secret conspiracy or agreement between two or more persons to injure or defraud another. Lacks six. A secret contrivance between two or more persons to defraud and prejudice another in his rights. Bouvier's eighth. Covenants, deceitful, fraudful, having the nature of or tainted by coven. Lacks six. Credit. The credit of an individual is the trust reposed in him by those who deal with him that he is of ability to meet his engagement, and he is trusted because through the tribunals of the country he may be paid. He, he is trusted because through the tribunals of the country he may be made to pay. Black six. See note. Note, credit means belief. It comes from the Latin word credere, believe, trust. Linked one's It also inextricably linked with one's name. If one examines the above extract from Black's first, the inherent fraudulent nature of the current credit system is abundantly clear. The only reason trust is reposed in anyone by the folks at the Federal Reserve is because an individual can be made to pay via the tribunals of the country, a type of transaction requiring no trust with a built-in insurance policy for the con. Credit equal belief, equal no substance, equal Federal Reserve notes. Creditor. Creditor includes a general creditor, a secured creditor, a lien creditor, and any representative of creditors, including an assignee for the benefit of creditors, a trustee in bankruptcy, a receiver in equity, and an executor or administrator of an insolvent debtor's or assigner's estate. UCC 120112, see note. Each type of representative of creditor listed above is in itself a precise description of the Secretary of the Treasury, who is the official receiver in bankruptcy over the bankrupt U.S. government. Reorganization Plan number 26, 1950, 5 USCA 903, Public Law 94, 564, Legislative History, page 5967. Such also describes the underlings of the Secretary of the Treasury, one of whom is the Commissioner of the Internal Revenue. In law, the most senior form of codified law on the planet is the UCC. There are only two kinds of people, debtors and creditors. The same is true in any statutory court. Judges and attorneys are also included in this definition. Creditor, per the Internal Revenue Code, also means employer. See note at employer. De facto, in fact, indeed. Actually, this phrase is used to characterize an officer, a government, a past action, or state of affairs which must be accepted for all practical purposes, but is illegal or illegitimate. Thus, an office, position, or status existing under a claim or color of right, such as a de facto corporation. Lacks six. Compared de jure. See note, color of law. Color of law. Note, the U.S. government is a de facto corporation, bankrupt, insolvent. De jure. Law, Latin, as a matter of law, existing by right or according to law. Black seventh, descriptive of a condition in which there has been total compliance with all requirements of law of right, legitimate, lawful, by right and just title. In this sense, it is contrary of de facto. Black six, compare de facto. Debt, not defined in the UCC. And at this point in time, I'm going to pause right here. We already went over half an hour mark or 30 minutes. And like I say, we want to make these strong, not necessarily long. But with that, I will say be peaceful, stay blessed, pray to pass God's tests. Later. Oh, wait a minute, people. Don't forget to like, share, and subscribe. Like, share, and subscribe. Like, share, subscribe. Leave a comment too as well. Leave a comment. Like, share, subscribe. Leave a comment. And I'll talk to you guys later.